Very good afternoon to everyone. The session is about to begin now. The Cooperation SIG Special Interest Group, I will say a little bit background about it, is a forum for discussing the broader internet policy issues concerning internet and internet governance, which are related to ethnic community interests, but which involve governments, other organizations and communities. I am presently the chair of the Cooperation SIG, along with Mr. Vikram Shrestha as co-chair from Nepal, sitting there. This year's theme for the Cooperation SIG would be WHOIS Challenges of Data Protection and Privacy. Little bit background, ethnic WHOIS database is always in the discussion and gained importance as IP addresses are exponentially increasing due to internet users and emerging IoT ecosystem. As you are aware, ethnic maintains the WHOIS database, which contains loads of information about contacts of network contacts for administration, for the network, technical contacts, and also such resources comprising the name, postal address, email, telephone, and other contact information for the organization and entity. WHOIS database is an important component of the registry system, whether it is the internet number resources or domain names. Globally, WHOIS service and protocol is the subject of intense discussion within and outside the numbers as well as the naming community. WHOIS database is structured in a manner where anyone can access the data anytime. During the last Cooperation SIG session at Kathmandu, Nepal, the discussion took place on the accuracy part of the WHOIS, how critical that is from the network operation and law enforcement point of view. However, two developments which have taken place recently brings the issue of data protection and privacy at the center stage. One is the Cambridge Analytica breached the data, where millions of personal data was swiped. Another is the European privacy law, better known as General Data Protection Regulations, GDPR, which has taken effect on May 25, 2018. The law enacted by the European Parliament requires companies to get affirmative consent for any personal information they collect on people within the European Union. Organizations that violate the GDPR could face fines up to 4% of the global annual revenues. This may call for significant change in the way WHOIS data will be structured in the future, and there will be profound change in the way we access the WHOIS database today. Thus, the data information will be subject to varied needs of the privacy, data protection, security, disclosure, and access. What information is being collected in the WHOIS database, what information is disclosed and protected, and most importantly, how the implementation part. The session will address and would deliberate and discuss these issues with various stakeholders and sensitize the ethnic community to the changing scenario of data protection and growing concern about privacy. What information should be there? Should it be just a name and email address? Should it contain the date of birth of an individual? Should it have a street address? Should it have the more data than that? That is going to be the publicly disclosed and publicly available. These are the questions that Roundtable would be discussing, especially in terms of how can privacy be protected? What are the key privacy principles that we should adhere to? What is the legitimate user and access? To discuss all these, we have a very distinguished panel here today to deliberate on all these issues. We have Mr. Craig, who is from Ethnic Legal Counsel, and the one who has a vast experience in this space dealing with WHOIS for the last 5 years. Then we have Mr. Sev from VP Ethnic ICANN in Pacific, who will bring the names perspective to the table. Then we have Mr. Jiao Feng from China Academy of Information and Communication Technology under Ministry of Industry and IT. He is also Vice Chair of GAC in ICANN, will bring GAC views, governmental perspective to the table. Then we have Raja Othman, Internet Security Expert from Malaysia, who will talk about CERT use case and value of WHOIS service. Thereafter, we will have the community interaction and deliberation with the community. Thank you. I would request now Mr. Bikram to say a few words.
Once again, welcome everyone, and good evening. My name is Bikram Shrestha. I am from Kathmandu, Nepal. I'm a co-chair of Corporate SIG. I'm going to present about a very hot topic. I know this is a very controversial one nowadays, and I know this is to provide content details to registry name holder of domain name in case of issue related to domain, including technical and law enforcement concerns. So in Nepal, just I am representing from Nepal, and Nepal perspective. So we all know that WHOI is a tool to access to public information. So overview in Nepal, privacy is a constitutional right in Nepal under Article 28 of the Constitution, and that include data protection principles. The constitutional provision also talks about protection of data, but there is no specific data protection law in Nepal. So current legal status in Nepal, the law in effect for the privacy and data protection on electronic form is Electronic Transaction Act 2006, which is very limited about specific data protection. Existing Right to Information Act 2007 has provided personal data as a limitation to the right to information. Public agency are not allowed to make public personal information, the Section 3. Some initiation took by different stakeholders in Nepal. Government, the Ministry of Communication, IT, Information Technology has prepared a draft bill on information technology. Currently, this is under consultation. The draft also does not address the data protection properly. So there is an Individual Privacy Bill 2018 has been tabled to the Parliament. So one of the initiation last week, the Internet Society in Nepal and Internet Governance Institution held expert consultants on 7th September 2018. So we think that the proposed bill does not address the issue of data protection adequately. So we need more multi-stakeholder discussion and consultations. Community to aggressively push for a new data protection law in Nepal. So still Nepal has under process in data protection law. So thank you for listening. Thank you very much, and welcome to Corporate SIG session.
Thank you, Vikram. Now I will request Mr. Craig to delegate.
Good afternoon, everyone. First of all, thank you very much, Dr. Govin and Bikram, for inviting me to participate in this session. I want to start by actually saying that when we talk about WHOIs, we are talking about a whole lot of different WHOIs. Is that such a word? We're not talking about one giant WHOIs, because there's a WHOIs for numbers, there's a WHOIs for CCTLD, country code names. Every country has their own WHOIs servers. We have a WHOIs for generic top-level domain, .com, .net, .org. Each of them operate their own registry system and publish their own WHOIs. So the first point I want to make is that When we talk about who is, we're not talking about one universal who is. We're talking about different who is's. And the way we deal with those who is's, I'm just going to say who is, the way we deal with them is that there is no blanket treatment. You treat each of them separately. As Dr. Govin and Bikram have shared with us, the thing about who is that right from the beginning of the internet, there has always been this transparency, this ability to trace who is behind a network, who is behind a domain name. Just like when you drive a car, you have a number plate. So if you hit someone, someone can actually look up who is behind, who's driving the car, who owns the car, who's responsible for the car. If you have a company, there is always a registry that records who is the shareholder, who are the company directors. There's that accountability where you are trading trademark companies that if you are using a name that belongs to someone else or you are working within a corporate situation, there is always a transparency and accountability so that you can always find out who is behind that. That's why we have that who is service. And it's important that that who is service continues to make the internet users accountable. But there's been a lot of talk about privacy. Privacy is not a new concept. We have always had privacy laws. And what does privacy law says? Privacy law says that your personal information, and remember when we say privacy law, we are talking about individuals' privacy. We are not talking about a company's privacy. A company does not enjoy privacy. We're talking about individual people. So when we are talking about privacy laws, what are the rights to privacy that you are talking about that would require the who is to be turned off, for example? So privacy law dictates or has some guidelines. One of the principles to privacy is that people should only collect information about you if it is necessary. Another principle about privacy is that you have the right to anonymity. So if you go to cinema to watch a movie, you have the right to go in and watch the movie without someone collecting your name, your email address, where you live, right? You should be entitled to walk in, watch a movie, walk out without someone collecting data about you. So the intersection between who is and privacy should always be a balance between what is reasonable in the circumstances. So what is reasonable, it has to be balanced between the accountability that I talk about, the traceability. So if you do bad things on the internet, there has to be a way where people, law enforcement, rights holders can find out who it is. So one of the examples I said was if Azrina here, for example, writes a blog and use azrina.com and the blog makes defamatory comment about me, I need to be able to find out who owns azrina.com so that I can serve legal process and assert my legal right. But if azrina.com, if Azrina is able to operate azrina.com anonymously with no accountability, then I think that raises a whole lot of questions about the way we want our internet to operate. So those are the kind of starting point I want to start about to get you thinking about privacy, data protection, and also the traceability, accountability sort of aspects of it. The other thing about GDPR, and we all know about GDPR, is, so what is it about the GDPR that's changed the way WHOIS operates? And we're going to talk a little bit more about that. So as Dr. Govin pointed out, it is this interpretation of one requirement that is actually affecting the WHOIS. The interpretation relates to the consent. So people have always regarded the fact that if you sign up on a domain name and in your terms and conditions of the domain name license, it says that I consent to my information being published on the WHOIS, which I think most of the terms and conditions around domain name registration will contain. That has always been regarded as acceptable level of consent to continue for the registry to publish your details on the WHOIS. But the GDPR has made some commentary in there that says that the consent has to be more explicit. So the question relates to how you interpret the level of consent before you can actually publish the information on whois. The last point I want to make about the GDPR is the extraterritorial application of that act. Just because an act says that it covers everyone in the world doesn't mean that it is valid, enforceable, or effective. If in Australia, if the Australian Parliament passes a law that says that every Australian citizen that goes through China is entitled to a cup of coffee as you go through the passport, it doesn't mean that that law can be enforceable against someone in China. So if I, as an Australian citizen, walk through the airport in China and I say, I'm claiming my cup of coffee now, and the cafe says, no, go and jump, there's nothing I can do. I can fly the Australian Act in a Chinese court, and they will say, go and jump. So by the same token, this is my analogy. So the European Act it's very clear that it applies to every single body that has a physical presence in the EU. But it is trying to regulate data that people hold about an EU citizen regardless of where it is. So if a European citizen seeks to enforce a right in India, for example, and a European citizen says to an Indian court that I have the right to be forgotten, and I want you, the Indian court, to enforce that right that's given to me by an European law, I think under doctrine of comity, which is a legal concept, and under the concept of sovereignty, the Indian court would say that, well, I'm sorry, we enforce Indian laws in this country, we don't enforce European laws, regardless of what it's trying to say. So that's the point I want to make. And I want people to think about the enforceability, not reading the act superficially and see what the act says, actually thinking about how physically a court in another jurisdiction would respect and enforce and for someone to comply with that law. That's what I want to say as opening. Thank you, Dr. Govind.
Thank you, Keg. While on the same page, I would just query you regarding how the APNIC Act presently implementing the privacy.
So APNIC is a body incorporated in Australia, and Australia has had privacy laws similar to GDPR, not exactly the same, similar to GDPR since about the 1990s. So APNIC has been updating its privacy policy and complying with the privacy principles, which are very, very similar to GDPR for the last 10 years or more. In short, the answer is that we are not doing anything special about GDPR. We continue to comply with the Australian privacy principles, which sets a very high bar about privacy. So we have transparent procedures, we have privacy policy, which is something that is required under GDPR. And we say very clearly to people what we do with the information we hold, how we collect them, how we use them, what else do we do with them.
Thank you, Craig. While Craig gave the numbers perspective, now we'll move on to the names perspective. We have Mr. Sev from ICANN about whois discussions in response to the GDPR, if you can.
Thank you, Chair. Thank you for allowing me to participate in this panel. I will share ICANN's work in preparing for General Data Protection Regulation, which is GDPR, that has resulted in changes to the registration directory services, or whois. So I note that there's a few new people here from the Pacific, and maybe this topic is not common to them. So just to recap, the GDPR was adopted by the European Union on 14th April 2016 and took effect on 25th May this year, uniformly across the EU countries. Organizations that fail to comply with GDPR by the effective date may face heavy fines of up to euro 20 million, or 4% of the global annual turnover. And so the aim of the GDPR is really to protect all EU residents from privacy and data breaches. It applies to all companies processing and holding the personal data of subjects residing in the European Union, regardless of the company's location. When we talk about the registration directory services of the RDS, or WHOIS, it's a publicly available and distributed directory containing information about registered domain names. So like for example, like ican.org. So each registrar and registry operator maintains its own database of registration data and provides access to this data via its own directory service. The RDS has evolved to serve the need of many different stakeholders, such as registrants, law enforcement agents, intellectual property and trademark owners, businesses and individuals. And the stable operation of the internet relies on the basic concept that you cannot run a hierarchical and decentralized system like the internet if you cannot find the people who operate it to warn of problems and coordinate responses to operational issues. In addition, the WHOIS system helps serve the public interest as it contributes to the security and stability of the internet, as it contributes internet by providing contact information to support issues related to consumer protection, investigation of cybercrime, DNS abuse and intellectual property, as well as to address appropriate law enforcement needs. So an important thing to note is that it is not a single centralized database. And this GDPR, it may affect the ICANN organization and domain name ecosystem in at least 2 areas. Number one is the personal data that participants in the domain name ecosystem collect, display and process, including registries and registrars pursuant to ICANN contracts. In ICANN, we have about 2,500 contracts with the registrars and registries that are located around the world, and bulk of them also in the European Union. Number two, the personal data that ICANN collects and processes for internal and external services. Over the past several months, ICANN.org has consulted with contracted parties, European data protection authorities, legal experts, and interested community stakeholders to understand the potential impact to personal data that participants in the generic top-level domain space, the GTLD ecosystem, collect, display, and process, including registries and registrars pursuant to ICANN contracts and policies in light of the GDPR. So the ICANN organization began engaging with the community at ICANN 59 last year. This was around June, on a matrix of uses for the WHOIS data. And the matrix was published in September 27 and helped motivate conversations with the community at ICANN 60 and beyond, including development of a series of legal analyses by a Swedish law firm. So what happened is that a proposed interim model for compliance was introduced in March and went through several iterations before its adoption as the current temporary specification, or commonly known as the temp spec, and this was in May 2018. So the temp spec, which was effective 25 May this year, provides a single unified interim model that ensures a common framework for handling registration data, including registration directory services, or WHOIS. It aims to ensure the continued availability of WHOIS to the greatest extent possible while maintaining the security and stability of the internet system of unique identifiers. Under the temp spec, ICANN's contracted parties are required to continue with a robust collection of registration data from both natural and legal persons, as well as technical information about a domain name registration. And to ensure compliance with the GDPR, access to personal data is now restricted to a layered and tiered access, where only users with legitimate purpose can request access to non-public data through registrars and registry operators. And users may also contact either the registrant or listed administrative and technical contacts through an anonymized email or web form. And registrants may opt in to have their full contact information made available publicly. And the ICANN board, in a temporary specification, encourages further community work to develop a unified access model that complies with the GDPR, while recognizing the need to obtain additional guidance from the European Data Protection Board. So the temporary spec is expected to be in effect until the ICANN community completes a policy development process that will result in a consensus policy for a revised WHOIS model. And the board must reaffirm the temporary spec every 90 days for up to 1 year. And ICANN.org will continue its discussions with the European Data Protection Board to ensure the WHOIS services can be made to be compliant with GDPR. And ICANN, as the coordinator of the global WHOIS system, would like to be centrally involved in any compliance discussions between European DPAs and contracted parties as they relate to the operations of the WHOIS, even at the local level. So finally, the draft framework published in 20 August is a working draft intended to facilitate further discussions with the European Data Protection Board and the ICANN community. It builds on a previous framework elements document published in June 2018 and outlines basic parameters based on ICANN.org's current understanding of the GDPR so that we can continue to seek input from the board, the EDP board. Having clear guidance may increase legal certainty for data controllers, these are the registries and the registrars, about whether a unified access model could be implemented, as well as assist the community in the expedited policy development process to consider the temp spec for GTLD registration data. I think I'll stop there.
Thank you, sir. While I will be coming to some more questions in the later part of this session, I will request Mr. Feng, who is a vice chair in the GAC of ICANN, to give a perspective from the GAC as well as the governmental perspective on this issue.
Okay. Thank you very much. Thank you, Chair and co-chair of this COP-SIG. And also, I would like to express my special thanks to APNIC for inviting me here to participate in this APNIC 46 meeting. I'm going to talk about the GDPR discussions within ICANN and GAC since Savi has elaborated enough content on the ICANN discussion thread. I will definitely spend more time and effort to give you a picture of what has been going on within the GAC. Perhaps, but I will touch upon those some elements of ICANN thread. So first, before that, I want to let you know that the WHOIS I'm going to refer is mainly about the domain name WHOIS for GTLD. So another thing is that, as pointed out by Savi previously, when we talk about GDPR, GDPR is affecting ICANN in two ways. One way is affecting the ICANN as an organization. Another way is affecting ICANN WHOIS policy. So mainly I will talk about the second one. So from my view, I'm not on behalf of the GAC, although I'm not currently the vice chair of the GAC. I'm share this slide with you and present those things to you in my personal capacity. This is my personal view. I think facing the GDPR, ICANN is kind of in a dilemma because I think the problem for ICANN is the global ICANN policy is facing the regional EU rules. There is some conflicts in this area, and the main conflict parts, as Savi has pointed out, that is the WHOIS articles in the registry agreement and registrar agreement. But we can see that ICANN org as an org had been doing a lot of effort to move forward to find a solution to this to comply with the GDPR, and this is the interim proposal dated January 12 this year, and next one is the cookbook. It was issued March 8 this year, and this is the most recently one, the temporary specification. It was put in place from 25 May this year. That was the day GDPR became effective. So after that is the initiation of the EPDP, because the temporary specification is a temporary policy. It's not does not follow the PDP procedure. So the community decided to have a EPDP, that is the expedited PDP, to have a formal policy after in 1 year, and to have a formal policy to deal with GDPR compliance issue. So now the EPDP is actually a GNSO PDP policy development process, but can be participated from other AC or SO. Also, we as SGAC had sent some members, some individual members to the EPDP to follow and contribute the discussion. So this is this slide also from my observation. It shows the different positions of each different group within the ICANN. The first one is when we talk about the GDPR issue and GDPR compliance. Within the community, I mean the ICANN community, there's a rough consensus that we should do something to comply with GDPR, but nobody says we don't. It's trash. We don't comply with GDPR. This is a general and rough consensus within the community, but different groups perhaps there is a slightly different approach, take different approach and views toward this issue. First, from the ICANN.org, ICANN.org always ask the proposal from the community to make a policy, because ICANN is a consensus-driven, community-driven policy-making body. So it is the community who makes the policy, and ICANN enforce those policies. So this is the position. And also ICANN.org always ask those policy change in relation to GDPR should get approval or some kind of recognition by the governments, especially EU members. And ICANN board is relatively the same with ICANN.org. And when we look at the contracted parties within ICANN, I mean the registry and the registrar, they are of the view that ICANN.org and the ICANN board should find a way to solve this problem. So they also assert that ICANN should not punish those who violate some kind of violate the RA and RAA because of the GDPR compliance. And when it comes to the IP protection community, like the record company, there is some discussion in the ICANN that they think that they need those WHOIS service to continue to access to WHOIS information for IP protection. For us as a GAC and GAC members, roughly we are of the view that as a GAC representative, we are not officials from data protection agencies, so we can act as a liaison to respective data protection agencies, but not in a position to prove anything I can produce. So also view that the current WHOIS structure should be maintained to have a continuous access to WHOIS data with legitimate purpose. So with that, the GAC actually we have a serious discussion and produce series of GAC consensus advice regarding the GDPR. That was listed in the previous 3 meetings GAC communique. That was Abu Dhabi communique, San Juan communique, and Panama communique. If you are interested in those languages, those words, you can go and find it. It is public. You can download it at GAC website. So in summary, the general position of the GAC, I show you a slide here. So the general position of the GAC, first one is the GAC highlights the importance of complying of the GDPR. The second one is to maintain the current structure of the WHOIS, to make it also accessible. And number three is the GAC does not envisage an operational role in the designing and implementing the proposed accreditation programs, but will still provide advice to the board and engage with ICANN on this issue. So perhaps in the future there will be some mechanism put in place. In the mechanism, there will be some accreditation for the legitimate user and authentication for the legitimate users who can have continuously access to the WHOIS data. So on this aspect, the GAC it says the GAC does not envisage a operational role in this mechanism. So the last one is the GAC knows the opportunity for individual governments and if some government wish to continue to have access to the WHOIS data, the ICANN should make sure there is continued mechanism to make some GAC member and also law enforcement agency to do so. This is, in general, this is the summary of the previous GAC communique. This is my summary. So next is what we are doing now in terms of the GDPR. Now, I and Savi had informed you that there is a ePDP process. So as a GAC, we as a group within ICANN, we also participate the ePDP process. We also formed our small special group, consists of several GAC members to follow that process. This small group consists of members like US, Iran, India, UK, and several others. So at present, the small group activities including we have drafted and produced our early input to some document within the ePDP, and also we the small group as a group have reviewing constantly the inputs and opinions from other AC or SO. This is what we are doing now. So looking to the future, so I also anticipate we will put a lot of effort and time into the discussion of the GDPR in the next ICANN meeting, Barcelona meeting, and I think I can stop here, and that is what basically I want to give you. Thank you.
Thank you, Feng. I will now turn to Mr. Craig again for giving a perspective from the WHOIS using the IP addressing word, continuity of service perspective.
Thank you, Dr. Govin. So what you have heard relates to the situation about the WHOIS in the domain name space. So the question for me is, what are we doing about the WHOIS in the IP address space? In a very short answer, we are operating as usual with no changes. The reason for that is this. At APNIC, so remember when I said privacy, data protection, that relates to individual persons' information, not corporate or companies' information. So at APNIC, 99.9% of our members are companies and corporations. And very, very few are from Europe to start with. So whilst we don't consider ourselves to be subject to the jurisdiction of the GDPR, and whilst we observe privacy principles that we are required to do under high principles of privacy, the position is that at APNIC, even with the GDPR in place, our WHOIS service is not interrupted, is not affected by this GDPR. And I think it is fairly similar for the other RIRs, if they care to comment. Yes. Thank you, Axel from RIPE NCC. Yes, from Michael from Aaron, the North American region. So from in this community, you can see that whilst the names people unfortunately are struggling with the WHOIS, in the numbers community for the IP addressing, our WHOIS is continuing uninterrupted and fully visible.
Thank you, Craig, for clarifying that. Now I will turn to Azrina for the CERT use cases and value of the WHOIS service.
Right, thank you, Dr. Govin, and fellow panel and the audience today. I'd like to share a bit of what we in the Computer Emergency Response team deal with on a daily basis. In dealing with CERT reports, these are incident reports that come to CERTs, and it comes from various sources. It can be coming from public, it can be coming from organizations, it can be coming from NGOs, okay, entities, and these reports are treated based on technical information that are made available to the team. One of the first things that we actually look out for as soon as we receive a report is to identify the IP address or the domain that's been affected, primarily if it's related to phishing and spamming. If it's related to malware, then we will be getting a sample of artifact, and from there we do a reverse engineering and try to identify if there's further information related to IP address still. So IP address and domain names are very important information that assist us in the CERT in doing response. Now, the nature of the work that we do, and I'm not just talking about CERTs, it's also applicable to SOC, Security Operations Centers. And what we do with this leads that we get, we do a lookup. So we do look up to the WHOIS database to identify who's the owner. And the information that we need is actually the email address of the contact for abuse. The next one will be the phone number. Third one will be the physical address, geolocation. Okay, so we need to know where this IP or domain owner is residing, whether the registration is located in the same country where the CERT is operating, or is it across border. And so that means that we may need to engage other CERTs from other nations and other entities. Now, from that information, we find certain challenges. So one of the challenges is the inaccuracy of the information. And we understand there are already processes in place by ICANN, for example, for us to report if the information is inaccurate. However, another factor, a very important factor, is accessibility. And without access to that information, there's pretty much nothing that we can do. Okay, so with delay in access to the information, if we are required to obtain some kind of authentication or legitimate access to the information, that will create further delay. And in incident response, we understand that time is of essence. Okay, and this is something in which we work around the clock. CERTs work even on weekends, and it's very common that incidents occur on Friday. Okay, and we work through weekends, trying to identify the source, trying to contact the owner, trying to verify if this is intended attack by the IP or domain owner, or they are being used as a launching pad. And I'd like to share one incident. One in which we did, it's normal that we receive a lot of reports related to phishing, CNC hosting, and we did a lot of analysis and tracing. We correlated these incidents, and over a couple of days and weeks and months, we found a trend that a lot of these malicious activities were originating from a single provider. Okay, so we've been continuously emailing them to the abuse contact, telling them that they need to stop this activity. We get an automated email response, right? We find that your report is important. We'll get back to you. You know, this is a standard response. So then one of the victims, because it affected a phishing site and involved a critical organization, they lodge a report. Once they lodge a report, the police comes in. They ask for the information of the owner of the IP, and it is located in Malaysia. So we've been trying to call, nobody picks up the phone, email, we get that standard response. Finally, the law enforcement came in to raid the facility. We found the place to be empty. Okay, there's no door, there's no tables and chairs. There's a phone sitting on the floor. Okay, connected to the line, and that's the phone that we've been dialing. Okay, so this is what we're dealing with. We're dealing with organized crime, and they have the resources to basically pay rental for an empty office. Okay, to create a dodgy contact, right? And that is a legitimate address, but with no tenancy. Then we have also situations where we find that the information is dodgy itself. I mean, it doesn't exist in the map, okay? And so these are information that delay SIG response, incident response, takedowns, okay? And in this particular case, in this case that I just shared, we identified the server where they were hosting in an ISP, and they were providing hosting services. They were actually connected very actively because the ISP finally tapped the network and identified a lot of traffic from the RBN. We're talking about Russian Business Network, okay, which has ceased operation until now. So this basically shows that they're very organized, and they hardly show up on site, physical. They're always dealing with the ISP over the phone. When the police wanted to take down the server, they basically claim that they will lodge, sue the service provider, the ISP. So these are the kinds of criminals that we're dealing with. They're very organized, and they take advantage. Now, having this information further suppressed, hidden from people, operators like CERTs, SOCs, law enforcement, it will make us even more difficult to pinpoint and quickly identify whether this is a valid abuse case or this is a crime. Okay. So that's the message that I'd like to share today, the importance of maintaining and having access, continuous access to the WHOIS database will ensure that we can assist better, okay, the public and critical organizations that are depending heavily on the internet.
Thank you. Thank you, Zina, for a very live example of how the WHOIS data continuity is important for the ethnic and the other numbers community. So I would now like to open the floor for question and answer session, 20 minutes, and then we'll again wrap up in the last 20 minutes. Thank you. Yeah. Yes, Paul.
Good afternoon, Paul Wilson from APNIC. A question for Azarina actually, which relates to some of the things that we hear at APNIC about the quality of WHOIS data. There's, I think we can treat WHOIS as having two sort of distinct sets of data. One set is the data that actually pertains to APNIC's own actions, so our allocations or assignments directly to members or organisations with whom we've got a relationship. So that's one set. The other set is a set of data that our members are obliged to lodge into WHOIS, and which they are responsible for maintaining, and where the sort of subject of that information doesn't have any relationship with us at all. And it gets a little more complicated because within that set there's even sort of downstream sets where the subject, where an allocation from APNIC has been made to one of our members, there's an assignment from that member to a downstream ISP, and that downstream ISP may be registering subsequent assignments. So what we hear, particularly from our colleagues and contacts in the US, is that the quality of that data gets worse as it gets further away from the registry. I'm just wondering if you've got any thoughts about that, if you've got any experiences of the same thing here, whether you find yourself hitting low quality or incorrect records and then having to follow a chain back to a record which, as I say, the record which you finally end up at, which might be an APNIC maintained record, hopefully is a more reliable record than what might be further down the tree. But that's a sort of distinction that we have felt the need to make, and yet we don't have very clear distinctions in policy between those different types of record. But I'm just interested in your thoughts about that. Thanks.
All right. So when maybe I need to be clear about what I mentioned just now is that when I speak about WHOIS database, we refer to various WHOIS databases out there. And in the case of IP WHOIS lookup, I have not come across so far of dodgy physical addresses that are being registered. But a lot of the time, we find that the unreliable data are residing under the domain. And these are, as you say, registries or sub-registries that are operating across the globe. And I do not want to mention some of the providers that are doing it. But they're very well known, and a lot of businesses subscribe to them for the domain registration. And we find that the quality deteriorates. Perhaps this is something that I've been in ICANN panel before and discussed about the importance of validating information before it gets recorded into the WHOIS database. Now, or even before granting a domain or an IP to an entity requesting for it, we find that there's disparate standards that are applied by registrars and registries the message that I get is that some registrars, for example, I take example Hong Kong, they had a very stringent standard okay, in complying to ensure that they validate. So the company has to provide evidence of the company registration before they even grant you a domain under that name that you're requesting. You can't be squatting on domain names and something like that. But there are other registries that don't really do that extra effort of validating. And that is when we get information that are inaccurate being recorded into the WHOIS database. Now, the problem when there's disparate qualities across registries, these malicious or criminals or people with bad intentions, they will go to the registries that are more relaxed, okay, with the policy. So it's a loss for business for those that are trying to apply a stringent standard, minimum standard. And those that are more relaxed are getting more business, right? So that's the trade-off that we find. And this panel was long ago held in Sydney. And I'm not sure up to this point how much progress we've gotten and how much enforcement can be done, because we understand the complexity of having this registry across the globe. So having policy is great, but enforcement is another challenge I find across the globe.
Just a quick comment too, and again, I want to emphasize the difference between names and numbers. In the names world, a domain name is, the fee is right, but it's also like $10 for a year of registration, and you can't expect. It's very hard to expect the registrar to spend a lot of time to verify the data. In the numbers world, our minimum membership fee, someone's going to correct me, but it's a few $1,000s for a registration. So our due diligence exercise is a lot more stringent because of that. Because the membership size is bigger, the cost of the registration is higher. We can and we do require association between the company name and the individual behind the application, driver's license or passport, identification that matches that data, so that we have a higher degree of confidence about the accuracy of the identity, not necessarily the phone number, but definitely the email, the identity. So that's the other difference.
Next, anyone? Bijan sir.
I'm Rajesh Jain from ISP Association of India. I have a comment on the question. Actually, my family has a rule that wherever I go, coffee is to be given. So thank you, APNIC, for making it happen. Now, see, this second part is privacy versus accuracy, as we have been discussing. On the accuracy part, the data resides at two places. For example, when the second assignment comes, it resides with ISP. It also resides with registry. So in that case, whether there is a need of responsibility that where the data will reside, or can we say that, okay, this will reside only with, for example, ISP and not with the IPNIC, or vice versa, whichever it may be there. Because in case of leakage, then the question comes that from where such data got leaked. And second part is on the question of accuracy. Accuracy, one is that on the part of the criminal, they are organized people. But in a normal case also, the people get shifted. The phone numbers get changed. So when security agencies SOC come to ISP, they expect the answer in a very, very short time. And when address is correct, phone number is not, so while somebody may reach the address and actually get that number changed, so I think we should probably, are we doing something to make sure that our address, our data remains fresh. Thank you.
To whom this question?
Anyone want to? What do you want to say? Whether the APNIC should?
I'm just saying that whether it should be at two places, data, or it should remain primarily at one place and. Or let me put it fresh. Why should APNIC need the data? RIR need the data for second assignment?
So that is actually a policy question. It's in the APNIC community established policy that says that the further assignment has to be registered with APNIC on the database. So it actually resides in our database, but the ISP populate that data onto the APNIC database. So that's the first question. The second one, we are very conscious at APNIC about data accuracy. And so even without any policy proposal, we are already doing data checking on an annual basis. So APNIC is a membership organization and our members need to renew their membership every year. So we know at least that the email account that we send the bill to works. Because if they don't pay the membership fee after a period of time, then you actually get a membership closure. So we know that at least one of the contact details will work. But beyond that, APNIC does an annual validation check of the email address and the data. But I'm very happy to see that there is a policy proposal to be discussed, I think, tomorrow that relates to data validation as well. So it'd be interesting to see how the community feels and the discussion that will come from that. And I think the policy proposal is suggesting a 6-monthly validation process to make sure that the data remains fresh.
Thank you. So anyone? Any question?
I'd like to add to the both related questions. When it comes to ISPs, service providers that are basically extending IP addresses to their clients and customers, who often also end up become hosting providers. They will own a range of IPs, and often these are the information that are less validated. So it's not the bulk of the IP that's obtained from APNIC, for example, or ARIN, but it comes from the ISPs that are delegating and extending this IP address to their customers. And that is a challenge that to ensure that the same due diligence is being applied across all the way to the final owner of the IP. And enforcement, as I mentioned just now, be it domain or numbers, the challenge is always to ensure how do we ensure that they are putting in the right data into the database.
This is a good discussion to talk about the accuracy, and as Paul said, I think it's almost very accurate up the top, and it gets less and less down the bottom. I know, Axel, I'm going to put you on the spot. I know at RIPE NCC, the database group was talking about this some time ago, and they were using this flag where they actually use green to signify that it's been verified by the registry at RIPE NCC, and an orange and then a red, so which kind of signify how accurate that was. That was a proposal, but I'm not sure where that went.
Right, we're doing something like that. The main distinction here is between the registry data, that is the data that we require our members to fill in and that we need to be fully accurate, and the other stuff that they are also putting into the database, which could be sonnets and limericks and all sorts of further assignments, which we don't have a direct influence over. It should be correct, but we distinguish between the two aspects of the RIPE database.
Just to share, this is not related to who is validation, but data validation. But I want to relate this to a situation when we are purchasing certificates. When I'm purchasing a pair or a digital certificate key, yeah, or keys to generate digital certificates, and I'm purchasing from United States, for example, and I'm in Malaysia. I find that their process is very stringent for certification authority. They will actually validate not just based on information that you give them, but they will actually go and browse your website. They will try to call the front desk. They will look for the name of the person who is trying to register for the certificate, whether he's really working there. And they put a lot of effort to actually verify. Before they finally, it takes about a week for them to validate, and then they will issue the key, which is in a token that gets posted, mailed, couriered to us, and we are given, to the address, right? So that's the kind of process that they put in order for them to issue that kind of credentials. And but as I said, and I understand from Craig that cost is one of the factors that will determine how much effort do you put in validating the data. Yeah.
Any other question?
So now we will be in the last phase of our deliberations here. We would be again asking the panelists few questions. So if I turn to the names community now, because numbers community, we had a lot of things here. So whether the Gdpr is from Europe, so how that if different countries are making different kinds of laws for privacy and data protection, how it is going to be implemented globally? As part of GAC, Mr. Feng, how are you, whether the GAC community is, which consists of more than 100 countries, are they on the same page on this kind of issue in the names case?
Thank you, Chair. Thank you for your question. Yeah. To me, yes, first, now in the GAC we have 177 countries. Now we only have significant policies like GDPR, which had affect the policy of the ICANN. Yeah, from my observation, there's a high chance that there will be other legislation or local rules or regional rules that will be affecting ICANN's global policy. There's a high chance that some perhaps a big economy or countries will issue their own GDPR-like rules or regulation. Perhaps from my view, that in the future, within ICANN, the ICANN community will face the same problem from other region or from other country. So perhaps the ICANN need another round or several other round of discussion or modification of the current policies. So when we talk about multi-stakeholder approach, yes, it does has value and does work well for quite a long time. But when it comes to the sovereignty of the state or the perspective of a particular country or state, so those I think those observations are different from what technical community think. There are always political trade-off, political calculation and analysis in the issues within our cyberspace. So I think in the future, perhaps a multilateral approach is still valid for a lot of issues. But for ICANN, I think for the ICANN, it does have a position that ICANN says it respects local laws and national laws in general. But to be when it comes to a specific case, I think it will require a lot of tasks, a lot of processes to do. That's my observation. Thank you.
Yeah, I can say that from ICANN's perspective, we are closely monitoring global data protection and privacy developments. We are also tracking developments in other jurisdictions, as ICANN understands that the landscape outside Europe is undergoing change, and ICANN will need to take into account the proposed legal review. One of the things that we're doing as well is on the EPDP, and also trying to work on a unified access model of how WHOIS data should be displayed. So, we encourage community members, stakeholders out there to really engage and participate in this process as we go forward.
Thank you. Would you like to comment anything on this?
I do actually. If we believe in this multi-stakeholder model of internet governance, and if we believe that this is the way we make policy around internet, then we have to be careful about government imposing laws that changes our internet standards. The WHOIS is a standard that's been developed in the multi-stakeholder bottom-up consensus way. You are here, I am here, we are here because we believe in this system of internet governance where the government don't impose the laws on top of how we run the internet. But the effect of the GDPR is that it has overwhelmed and subserved our WHOIS policy. So as a comment I would like to make is that if there are lawmakers in the room and they're making laws, they ought to be conscious of the impact that it has on the internet community and the things that we are trying to do. If those governments believe, ironically, the European Union countries believe in the system of multi-stakeholder form of internet governance. Whether the GDPR affecting the WHOIS is deliberate or inadvertent, it has the effect of affecting how we come up with consensus decisions about this. And one of the things that I think people have to be conscious about is that if you step beyond your jurisdictional limit and affect other countries, then in the world that we live in the internet governance, we're going to end up in a whole lot of pain when you have different governments trying to legislate over each other. And poor ICANN, you live in America, so US government, as you say, is considering legislating on the WHOIS. And many other countries will start doing similar things, and what does ICANN do?
Thank you. I think any other question? Floor, yes, Mr. Jain.
I would only say, Brajesh Jain again, one word, one internet should probably prevail. Now my question is, very often a situation comes up, for example, this is a live case, that IP address allocated by other RIR used by the hosting center. And when the query came, it took quite a while to go back to the other RIR and find out, and it was quite a bit of difficulty. So then security agencies were telling us that please don't route addresses at source addresses in your network from addresses from the other RIRs. Does somebody can comment on that? And while we have resisted that, but that becomes a real issue for us.
Any RIR sitting here, they can comment, would like to comment on this? No? Okay. So anybody wants to, anyway. So my another question to the panelists is like, the new technologies which are emerging like blockchain or the AI, how that is going to affect this WHOIS database in future, maybe not immediate future, maybe, how if people apply a large database of IP addresses and domain names, so that, AI application to deep learning kind of thing or deep digging kind of thing. So whether that time how the privacy issues are going to be tackled, if panelists can answer any one of them.
I don't imagine that it would actually affect it. With IoT, obviously we are already allocating and distributing IPv6 addresses, and there's a lot of them. And so the issue is already alive about, but at RIR levels, we are distributing and allocating at the top level. So we don't have visibility in terms of privacy of the sub assignments, further down the chain. The privacy, I think, issue lies further down and not at the RIR level. So sorry for a cop-out answer, but I think from our perspective, I don't see that as an issue that affects how we do business.
So another question is, when like GDPR says if some misuse of the privacy happens, then they will collect reimbursement of some 4% of the total revenue. Is this also going to be affecting in some of the cases of the who is in the number space or namespace? How it is, if it happens, I'm not saying that, how it is going to be taken care.
Sorry for dominating this conversation. So, Ireland came up with a whole lot of tax incentive for companies to be, for tech companies to be based in Ireland, right? So Microsoft, Google, Apple, they all have presence in Ireland because they wanted to take advantage of the tax, the very low tax concession. It will be very interesting. So, in Australia, if I buy a Microsoft 365 subscription, if I buy a Google subscription for a very, very long time, I'm actually contracting with Microsoft Ireland, Apple Ireland. And that's because when the profit they make in Ireland is taxed at a concessional rate. It will be very interesting to see how many of these companies leave. And I think they've already started to leave Ireland and starting to contract from, and they're moving their customers from Ireland into the US companies because they are trying to get themselves out of the EU laws. So we've seen the start of the trend. It'd be interesting to see what happens sort of slowly and how the kind of world deals with it itself.
Azrina, you want to comment something? Okay. Any other questions, please? So we are towards reaching to the, before I wrap up the session. So any panelists want to say anything? Anything left out or want to say anything?
Yeah. In face of any discrepancies or issues in relation to whois database, I feel that it's still very important for those who are operating whois database to have an outlet or a process for CERTs or SOC or any entities to report, to notify, and not just because of inaccurate information, but inaccessible information, for example. Because I find that a lot of the process, not for numbers, but for domain, it's pertaining to only misinformation or inaccurate information, while there are situations where there's even lack of records. And we need an outlet or channel to escalate this issue. So that I feel is important to have that process in order to step up, to ensure that the operators step up in providing their services, in recording this information more accurately and timely. Yeah, thank you.
Thank you. So I think we had a session here on the whois and the data protection and privacy issues. We had 5 panelists here. Mr. Bikram, vice co-chair, started with the perspective of Nepal, how the Nepal law on this privacy is working there, and they are going ahead with the another law which will bring some privacy matter into their law to work on this kind of thing. Mr. Craig talked about the who is, and he distinguished between the who is from the names perspective or the numbers perspective. He talked about names, numbers about how the things are moving right now in the ethnic region, and how these are going to help. Not much changes are required from the GDPR point of view. They are already taking care of the privacy issues and the how correctly they record the addresses and those kind of thing. And even RIPE and ARIN is going to do that kind of thing. That is what was talked about. And most of the companies in the ethnic Asia Pacific region are mainly confined to the Asia Pacific, so where the GDPR is not going to be affected much onto that. From the ICANN perspective, Mr. Sev talked about how the ICANN global stability of the internet and its security point of view, they are working towards the various aspects of the GDPR, how to make it compliant with the privacy point of view. Continuing to that, Mr. Feng talked about the GAC views and the governmental perspective, how the various issues there, the coming out with the EPDP process which is going on, and hopefully this will be, I think, coming up in the next Barcelona ICANN meeting, and prior to that they have come out with the global views on how the privacy and protection is going to be embedded in the ICANN and the GAC bylaws. Then Mr. Craig again talked about how the continuity of the services is required very much in the numbers case, because the numbers are more critical than the domain names, in the sense that here accuracy part is taken care because of the high value of the IP addresses compared to the domain names. And further, the Azrina talked about the CERT experience in Malaysia, how the CERT is working with the community, with the multi-stakeholder process, certain accuracy part of how they are tackling it, and what are the issues they are facing in the correctness of this WHOIS database, and how the privacy is going to play into those kind of things. So this is the brief, but what takeaways which we can take from here, I believe, is, I think, panelists, the last line, I would like every panelist to say something about it. Starting from.
I think I've said too much, so I'll shut up.
Yeah, I think pretty much said what I need to. I just want to make sure that the accessibility to the WHOIS database is very pertinent and very important for those in the security fraternity.
Okay, one line is balance. So I think if you make WHOIS invisible, I think the balance has gone too far the wrong way.
Yes, we need to balance whose data should be disclosed and which is not to be disclosed. That should be done, and some credentials should be maintained. That will be the recommendation from.
So my final comment would be that governments are thinking different compared to the community from the perspective of policy, public policy issue and security issue. But I think we need talk between governments and the community.
Yeah, exactly. I also support that last comment about how engagements at the local level with our governments and also regional level. And just on the final word around WHOIS, ICANN is working on a unified access model, so we expect participation from the community and encourage input into that process as well on the EPDP. Thanks.
Thank you. I would like to thank again the panelists and the audience here for a good interaction on this important issue of WHOIS database accuracy, privacy, and the protection point of view. Thank you very much.